Number one, it's warfare is makes it more exciting. Obviously it's not physical warfare. You don't get into fisticuffs with your opposite counsel or the parties in a court of law. Much advocacy is about grace and poise and being able to say tough things. As they say, an iron hand in a velvet glove. Much of advocacy is about iron hand in a velvet glove. So it's not warfare in that sense, but warfare is an exciting way of looking at it, because war is strategy, trial is strategy. In war, you are thinking 10 steps ahead, not thinking short term, but thinking long term. In trial, you are thinking long term, not short term. Warfare is about knowing the opposite side's vulnerabilities and exploiting them within the framework of law or rules. Trial is about that. There are two people fighting for dominance and supremacy. In a trial also two people are fighting. One has one narrative, the other has the other. Then there is a judge who decides that. War has rules, sometimes not, but supposed to be having rules. Trial has rules. So that's why because it's a contest, right, between adversaries. So that's the reason it's a good way of a framework of thinking in that sense. Yeah.
So I remember somebody had told me once that, litigation is like infinite chess. And you can go on, filing new things. Most probably, there's no checkmate. Until there's a checkmate, at least you can go on taking different actions. And so, do you think there's a parallel there?
Well, yes. Obviously, all of these things that we talk about today in terms of tips and tricks should be used responsibly and and guidance. But yes, there is a direct parallel there. But what we talk about, I think, really is how do you approach it in a way that's within the framework of law, it's ethical, doing the right things the right way for the right reasons, as far as civil, criminal, and arbitration law, are concerned.
Okay. So, what would you say that if there is somebody who's young and is trying to learn the art of warfare in trial? So, how do they go about it? What is the starting point for this?
So, the most fundamental is knowing the law. You cannot expect to fight better and fight well until you know your tools and what are you working with. So, very, very strong understanding of a CRPC, Evidence Act, IPC, CPC, the Arbitration Act, of course the Constitution. These 5-6 which form the core of any lawyer are very, very important, because this is your repository of weapons or the things that you can do. You need to acquaint yourself with it. How do you acquaint yourself with it? Bare acts are the best way to do it. Then simple textbooks. Don't graduate to commentaries. Take the simplest that a subject offers. For example, an Avtar Singh on a contract is a very good book still. A Bangia on a tort is a very good book because it tells you what you need to know. Then of course you can build on it. Basics to pehle samajh aa jaye sare. Then you can keep adding case law and new judgments and so on. But let's have those foundational principles intact. और लड़ाई सारी principles की होती है at the end of the day. Every section has an underlying principle. You may be lost in sections sometimes in a bare act, but if you don't forget the principle, you'll do it right. Right? There are different things. There's a principle, there is a rule. Rule would normally guide you in a given situation. Principle would tell you what the philosophy is. And if you get the philosophy part right, for example, every right has a remedy, that's a principle. Nobody should be allowed to be an unjust enrichment of something. That's an equity principle. It's a principle. It's a philosophy. Then there are sections in the Contract Act that help you understand it. Estoppel was a principle before Evidence Act came into the picture, 115. You cannot be allowed to breathe hot and cold under the same breath. That's a principle. If you remember the principle, you never go wrong. So just a mastery of these basic principles. Then of course, you can't learn to swim in a library, right? You'll have to be thrown into the pool or the deep end of the pool, and that's how you learn to apply these principles to real life situations.
So you start doing matters, basically.
Start doing matters, start obviously observing very keenly what's happening in a court. There's so much that can be learned by just being in a court. I love, sometimes litigation is very inefficient. For example, you have matter number 40 in the High Court and there are 40 matters before you. But being there is a privilege, because you're learning from the combined wisdom of about 100 people who appear on those 50 matters. And hundreds of years of experience you've been able to gather, and it's distilled in the court. What are the contentious issues? And they keep coming up again and again. It's broadly, those 50, 100 issues in any law. And so being in the court, keenly observing, working with the right people, associating with right people is very, very, of course, important. Yes.